Good afternoon. For the benefit of our web recording, I'm going to repeat that we are at the 18th Annual Civil Justice Symposium for Judges here at the Law and Economics Center. We are delighted to have all of you with us. As mentioned earlier, this is the 50th anniversary of the Law and Economics Center, started in 1974. Good, yes. We are very excited about the programming that we have this year, including our evergreen program of the Civil Justice Symposium. So it's a delight to have all of you with us. In honor of that 50 years together, as in different programs, everything from teaching academics to judges to attorneys general in the states to other policymakers, we really want to focus on understanding the legal system in every one of these divisions. And one of the ways that we do that is by encouraging the production of scholarship in our academic program and encouraging ways in which all of our divisions are constantly looking at exploring the system in order to find ways to make it better. And in our 50-year retrospective, as we're looking at all the things we've done across the years, it seemed appropriate to also consider a retrospective on the civil justice system as the topic of our keynote address. So today our Luncheon keynote will be on the economic analysis of the civil justice system across 50 years, how much has changed, and how much remains the same. And I'm delighted to introduce our keynote speaker today, who I thought would be perfect for this panel, Mark Behrens. Mark Behrens is a partner at Shook, Hardy & Bacon, where he co-chairs the Washington, D.C.-based public policy practice group. Mark's been involved in civil justice issues, liability law, and defense litigation for more than 25 years. And allow me a point of personal privilege here. I entered my legal career as an associate at Crowell & Moring many, many years ago before entering academia. And I had the privilege of working under a senior associate at Crowell & Moring who was a great mentor and a wonderful colleague, and that was Mark Behrens. Mark helped shepherd me into the legal profession, and I owe a great deal to Mark for that. And thank you, Mark, for all that you taught me in those years while we were together at Crowell & Moring. I also had the privilege of co-authoring some pieces with Mark, who took a young associate under his wing to help explore the civil justice system in the public space. And it's something which Mark was honing his skills at then and has certainly become a master at helping us to understand at a very deep but also accessible level the intricacies of the civil justice system. Indeed, a substantial part of Mark's practice today continues to involve working on understanding the civil litigation environment through commenting on state and federal legislation and state and federal rules, through work in amicus briefs in the courts, and through continued legal scholarship. In fact, Mark has published more than 50 scholarly articles in leading national law journals and law reviews, including the Harvard Journal on Legislation and the Texas Review of Law and Politics. Indeed, in 2016, one of his articles was recognized for being one of the top 5 most cited articles out of the Cornell Journal of Law and Public Policy. So Mark is an established scholar as well as a litigator. In addition, he has also produced more than 150 amicus briefs in state and federal courts across his career, including at the United States Supreme Court, federal appellate courts, state Supreme Courts, and other state appellate courts as well. In October 2015, Mark received the U.S. Chamber Institute for Legal Reform's Individual Achievement Award, and in July 2016, he received the International Association of Defense Counsels Joan Fulham Ehrich Award for Exceptional Leadership as Civil Justice Response Committee Chair. He has a long bio and extensive experience and expertise, as I mentioned, all of our speakers do. And so I do encourage you to look at the full bio on the website. I'll just end with Mark has also been a teacher and a professor. He has taught advanced torts as a distinguished assistant visiting professor at Pepperdine University School of Law, and been an adjunct at the American University Washington College of Law. He is a graduate with a BA in economics from the University of Wisconsin-Madison, as well as receiving his JD from Vanderbilt University. So without further ado, to talk to us about 50 years or so of the past and what we can learn from it for the future, I introduce Mark Behrens.
Thank you. Thank you so much, Donald, Professor. It's amazing. It's always an honor to come here and listen to the judges and especially to be invited by Donald and the very gracious things he had to say. It teaches you to be kind to your associates, because someday they may accomplish more than you. And that's certainly the case with Donald and what he's done with this program, and taken the great job that Henry and his staff had done and just continued to take it to a different level is really amazing. I remember when I was in college, I used to come here. I had a summer associate position at a small plaintiffs firm in Vienna, Virginia as my first year, and I used to come to what was then the George Mason Law School law library to work, and it was a former department store with an escalator that went up the middle. And to see what has happened in the last 30 years with this school, with a new building and the rankings just going up, it's one of the better success stories in academia today across the country. This is a fun topic that I was asked to give today, and a really challenging one, because it's a lot easier. Usually somebody says, I want you to be on a panel and talk about third-party funding or nuclear verdicts or something like that. But to cover something, to cover 50 years of tort law, I guess the only thing that makes me qualified for that is I'm old enough to have actually been doing it for most of this time period, and certainly learned from my senior colleague, Victor Schwartz, who has. So in thinking about it, I think what I'm going to do today, can you hear me? Is the mic on? Otherwise I'll speak up. Okay. Is to kind of break this down into what I see as the first tectonic shift in tort law. Instead of getting into the weeds, I thought today what I would do is focus on some really big eras or seismic shifts that have influenced civil justice in America through today over the last 50 years. And then talk about some of the things that we're seeing now, because I think we're in an era now of the latest tectonic shift in torts and where this may be going out in advance. So in thinking about, we're really lucky in a sense that this is the 50th anniversary, because this goes back now to the early 1970s. And you may remember, for those that weren't practicing then, but certainly from torts, there were seismic changes going on in tort law coming out of the 1960s, the late 1960s, and into the early 1970s. Maybe a reason why this was formed at that time. But some of the changes that were occurring then, you may remember that contributory negligence had been a complete bar to recovery under common law. That transitioned into comparative fault system for the plaintiffs, where no longer, if you were 1% at fault, would you be completely poured out of court. Some states went the exact opposite with pure comparative fault and said, even if you're 99% at fault for your own injury, there are some states where you can still sue. Most states took a moderate, thought, well, we're going to go from one extreme to the other. Let's find a middle ground. Most of you are probably in states that say the plaintiff can sue unless he or she is 50% or 51% or more at fault. But that was one of the changes. That was a really substantial change in tort law. About the same time, in 1963, the California Supreme Court in Greenman versus Yuba Power Products, I'm taking you all back to tort class, we're in a law school, right? Comes out and develops for the first time strict products liability. California is the only state that had that at the time, but 2 years later, the restatement second of torts comes out and adopts the section 402A strict liability for the first time. At that time when they adopted it, it really wasn't restating the law, because it was only law in California. But within 9 years, it became the law of the land. Now almost every state in the country has a form of strict products liability, many referring back to section 402A. And at the time these were going on, there were changes going on in the courtroom as well, where both non-economic damages and punitive damages both started taking off about the same time this had happened. Non-economic damages had always been around, and there were some early pioneers in the plaintiff's bar like Melvin Belli that had figured out how to make non-economic damages bigger, but we start really seeing what's now ubiquitous, jury anchoring, taking off. And soon, by the early 1970s, there were people writing that non-economic damages had become the grist mill for the tort system, that increasingly they were the largest part of tort awards, largest single item of recovery by the 1970s, far exceeding medical expenses and lost wages. And then in the punitive damages world, this to me, even every time I give this little pitch, it's always amazing to me. So, because today we think of punitive damages as an everyday occurrence, almost. But for most of American legal history, punitive damages coming from common law England were reserved for intentional torts. Those torts that you learn in the first 2 weeks of law school, assault and battery, false imprisonment, things like this. It wasn't until fairly recent modern legal history that punitive damages begins to be awarded for something less than intentional wrongdoing. I looked here, the first product liability case to allow punitive damages, where it was up on appeal, was a case in the mid-1960s, Tool out of California. By 1976, this is the year I moved to Washington, 1976, there were only 3 product liability cases where punitive damages had been awarded upon appeal. I mean, fairly recent. That's pretty amazing to think that in 1976, there were only, if you were to, they didn't have Westlaw in those days, but if you went on Westlaw and typed in product liability, same sentence, punitive damages, you would have gotten 3 hits. Pretty amazing. But what happened at that time was that courts started loosening the standards away from intentional torts to things like gross negligence, reckless indifference to the rights of the safety. Punitive damages moved from your first 2 weeks of tort class into the law of general negligence. And you combine that with those other changes that I talked about, where plaintiffs now could sue even if they were substantially at fault for their own harm, and you get mass torts. The combination of allowing plaintiffs to sue plus the addition of strict products liability now led to the first mass torts. The first one was a cholesterol drug called MER-29. And then all of a sudden, you put together the ability to have a mass tort with the watering down of the standards on punitive damages, and you start getting awards that are coming out very frequently and in bigger and bigger amounts. So this is the law. At the time the center was created, this is what was going on in the courts. Okay? Very, very substantial pro-plaintiff changes made in a very short period of time that had transformational effects on our tort system that continue to today. We still live with all these rules today in our courts. Okay? So in the 1990s, and when I first started working, was really coming into an era of what I would call recalibration and some stabilization. Most states reacted to these changes by adopting product liability reforms, joint and several liability reform. Joint and several liability in most states went kind of the way comparative fault did on the plaintiff side. Many states moved to having a fair share liability system or some sort of modified joint and several liability. That was a reaction. Other states adopted reforms on punitive damages. Some capped them. Some raised the standard or the burden of proof on punitive damages. Many states passed what we call innocent seller laws, which if you're a retailer, that you can't be strictly liable for selling, let's say somebody buys a toaster that's in a box and it's defective and the house burns down, that as long as the toaster manufacturer is available to be sued, then you go get your money from the toaster manufacturer, not from the retailer that had no way to inspect or test the product on its own. So the tort reform movement that was alive when I first started practicing in 1990 really was still an attempt on the defense side to recalibrate for these really substantial changes that occurred. And it wasn't just in legislatures, but the Supreme Court was understanding what was going on in torts and how the pendulum had swung the other. Maybe it had been too far oriented towards defense when plaintiffs really couldn't get their day in court. But very quickly, the pendulum went all the way to the other side. And so part of the recalibration that was occurring wasn't just through legislative tort reform, but at the Supreme Court level. 1991, the first case in a case called L.L.P, where the Supreme Court expressed concern that punitive damages had, quote, run wild. So this was starting to get the attention of the folks on the high court. And in a series of decisions, the court stepped in and adopted both procedural and substantive limits on runaway punitive damages. Most of you may be familiar with, for example, the BMW versus Gore case, where the court came in with its now famous guidepost to put some safeguards against excessive punitive damages. And in 1993, in the Daubert decision, the court stepped in and interpreted then Rule 702 to say that judges have a gatekeeping responsibility to make sure that the evidence that's being heard by juries is reliable. So I have some other indicators. This is almost like a time machine, but some of the other indicators of recalibration that was occurring in the early 1990s. How many of you remember the 1994 McDonald's hot coffee case? Right? That was occurring now too. That was early in my career. That became the poster child of lawsuit abuse. Now I know on the plaintiff side, their narrative was that Ms. Liebeck had horrific burns. She was very seriously injured. And nobody was trying to diminish her injuries. But to the average person in the public, they saw this case as an example of lawsuit abuse. The McDonald's hot coffee case probably did more for the tort reform movement than any ad campaign that companies came up with. I mean, it really crystallized to the average person, things have really gotten out of hand in the United States. And then in 1997, again about the same time, the Supreme Court, in an asbestos case, says the asbestos litigation is in a crisis. And in the late 1990s, 1998, the American Law Institute steps in with its restatement third, restating the law of product liability to try to have some clarification over what is strict liability. How strict is it really? Particularly when you talk about design defect or failure to warn cases. So we had this change in the 70s, coupled by 10, 20 years of recalibration. Then there was maybe a little change, I'll call it, big for some companies, but not for a lot, is that in the late 1990s, the sort of next major change we saw in tort law was this linkage between the plaintiff's bar and state government in the state tobacco litigation. Multi-billion, $250 billion or so settlement was really the first time that there was coordinated litigation among many plaintiffs' firms and the states. And we've seen that model be replicated or attempt to be replicated many times, sometimes without success. If you look at the firearms litigation, there was an attempt to basically do what they did to the cigarette industry. It didn't work. There have been attempts to do this with lead paint. It didn't work. But the more recent success for the plaintiff's bar is in the opioid litigation, where it wasn't the state government suing now, but municipalities. And so we are starting to see, and today we continue to see efforts to take the public nuisance and turn it into a super tort that is a remedy for social ills. And you're seeing it now with some of the climate change litigation as well. If you were to go back and read what are the requirements for public nuisance, they would not support these litigations. But the idea is they're never going to get to trial because there's always going to be a settlement because of the dollars involved. That was sort of the next change. But again, that's not one that affects probably most plaintiffs' firms or most defendants, but it was a very substantial change in the law. And then coming out of the 2000s, what I started to see is not so much broad tort reform efforts, because many states by this time had already done things like reform joint and several liability. Most states have innocent seller rules. Most states have some sort of reforms on punitive damages. And so legal reform became much more rifle shot to deal with specific problems that they came up with, as opposed to like, across the board issues. So things like 2005, the Class Action Fairness Act at the federal level was an attempt to deal with some counties that were essentially creating national law through class actions. And it was an attempt to federalize multi-state class actions so that one local court wasn't creating national policy. And we've seen a number of states pass asbestos transparency to try to deal with manipulation or suppression of evidence, as one judge found, where plaintiffs' lawyers are file trust with the bankruptcy trust after a tort case in a way to manipulate the evidence that the juries hear and make sure they don't hear evidence about certain exposures the plaintiffs had. So we kind of come into the last, let's say up to the pandemic, and this is where we've been. We had one really big shift, and we spent 30 years trying to adjust to that. My thesis is we're now in the beginning of the next seismic shift in civil justice that is going to be as influential as what we saw in the early 1970s with comparative fault, punitive damages, and so forth. And these shifts are driving, what is driving them is different than what we saw before. What we saw in the early 1970s that led to the seismic shift were substantive changes in the law, like going from contributory negligence to comparative fault. That was a substantive change in the law, right? When you take the standard for punitive damages and go from intentional tort to recklessness, that is a substantive change in the law. What we're seeing now, though, are dramatic changes that are not necessarily being driven by changes in the law, but by other factors. Some of them are changing attitudes by jurors that we heard about on the last panel. Third-party litigation funding, and I'll talk about some of these others, and nuclear verdicts. So, it's interesting. I've probably given 3 or 4 talks like this on nuclear verdicts in the last year and a half. I don't recall ever talking about that topic before the pandemic. There have been a number of studies that have come out just this year. The U.S. Chamber Institute for Legal Reform put together a report that looked at verdict data over 10 years, put together with my colleague Carrie Silverman. Fantastic job where they looked at verdicts. They defined nuclear as $10 million and up, and they looked at all nuclear verdicts going back a 10-year period. This was a supplement to an early study that stopped at the pandemic. Why? Because the courthouses were closed. So they thought that's not a fair sample size to see what was happening during the pandemic. So the first study looked at 10 years up to the pandemic, and this newer study that came out this year looks at that data post-pandemic. And what we're seeing, what the data show, is that the number of nuclear verdicts, one thing that astounded me, because remember we talked about by 1976 there were only 3 cases with punitive damages in a product liability case. In the last decade, there have been more than 1,400 verdicts of $10 million or more. I mean, the nuclear verdict is becoming the regular verdict. I mean, it's quite astounding, but that's what's happening. And not only are the verdicts becoming more frequent, but they're becoming more severe. So what the data looked at was different bands. They said, let's look at 10 million to 20 million, 20 to 50, 50 to 100, and then 100 million and plus. And what they saw across the 10-year period is that the verdicts were moving from the lower end of that band. Let's just take the 10 to 20 million dollars. 10 years ago, the average verdict was closer to that $10 million floor. Now, it's up close to that $20 million ceiling for that band. And that's true with all of the bands. The verdicts are moving up and up, both in size and frequency. Rand Institute for Civil Justice did their own modeling this year, looked at a much, much bigger database. and they found the same thing. And just about 2 or 3 weeks ago, I saw where Swiss Re Institute came up with a very substantial report that again looked at their own data. The methodology is a little bit different, but the conclusions are the same across the board. All of these groups are looking at the issue using their own methodology, but all coming to the same conclusion that the nuclear verdict is a real thing, and it is getting much worse. What's driving that, as I said, isn't necessarily linked to substantive changes that have happened in the last 2 or 3 years, because they really haven't. It's being driven by much more effective tactics by plaintiffs' lawyers, this reptile theory. Michael, you could teach me about that. I'm not the guy that knows the reptile. But it's try the company and not the case, right? Put the company and the conduct and the wealth on trial, and less focus on the person that's injured. Make the jury angry. And then plaintiff anchoring or trial anchoring, that's, when you have pain and suffering awards where there may be great variability in what people think is pain and suffering is worth, where we don't have a market, psychology will tell us, the psychologist studies will tell us human behavior is to grab onto any number that's out there. So for example, if I'll just break it down to a real life example. If I were to take any of you and go to a home in, let's say, Bel Air, California, one of these mega mansions, and say, what do you think that's worth? You probably would have no idea within $5 million what the value of that home is worth. Now, if I tell you, well, the one next door just sold for $15 million. Okay, whether you believe me or not, you're going to grab that anchor, and that's going to help you decide what the value of the house I'm pointing to is, right? That's how it works. So if we tell a jury the damages are worth $15 million, they're going to do the same thing you do when you comp real estate. They're going to grab that figure, and it's going to anchor their decision on whether the verdict should be higher or lower for the plaintiff in the case. And what we've seen is the more you ask for, the more you can get. So 20 years ago, plaintiffs may have asked for $3 million, and they got it. 10 years ago, they were asking for $10 million, and they get it. So now why not ask for $25 or $30 million? Because they might get it. In a worst case scenario, the jury thinks that's excessive and they cut the number in half and they come back with a $15 million award. It's still much bigger than that ask would have been 15 years ago, right? This is what's happening. And, hats off to the plaintiffs' lawyers. They figured out how to crack the code to manipulate juries into bigger and bigger awards. And that's what's happening. That's not a substantive change in the law, and they're doing it in an environment where jurors today, as we heard on the last panel, are much more skeptical. Apparently judges are too about corporate behavior. But we have a society today where people are much more skeptical of large corporations. They're much more, particularly when you look at younger juries, the kids coming right out of college today, they see profits as evidence of wrongdoing. They do. And they don't trust science. There are many people today don't trust science. They don't trust the regulators to do their jobs. And so we have this populism in the country, and you put all these factors in there with anchoring and reptile theory, and you get your nuclear verdict. The other big change that's occurring, and we're going to hear a lot more about this, so I don't want to go too much into it, is third-party litigation funding. Maya Steinitz, who's a professor at Boston University, who's really has followed third-party litigation funding in the U.S. since it started here about a decade ago, was on 60 Minutes last year around Christmas time. And she said litigation funding is fundamentally changing civil justice in America because the funders are deciding now which cases get brought, how they're litigated, when they settle, and for how much they settle. But this is quietly going on in secret, as she said. One of our 3 branches of government is fundamentally being changed by an influence that's there, but you don't see it. It's like the invisible hand. It's there, but you don't see it. The $15 billion figure that has been put out there for how much funding is available now, there are some estimates that it'll double by the end of the decade. There's more money pouring into this space than you can believe it. So much that I have an interesting story. So I'm based here in DC, but I live in Naples, Florida. God bless my wife and kids. Pray for their safety in our home this week. We're not on the coast, but we have some friends that I think are pretty wealthy. They have one of those like Malibu style homes. It's like literally right on the beach. And anyway, 6 months or so ago, we had them over for dinner and we're visiting. And the wife says, "Hey, Mark, you're a lawyer, right?" I said, "Yeah." She said, "Can I ask you something?" I said, "Sure." She said, "Have you ever heard of this thing called litigation funding?" And I said, "Yeah, I actually know quite a bit about it. I lecture on it. I've written about it. Why?" And she said, "Well, our money manager is trying to get us to put some money into this new investment vehicle. He says it'd be really good because it's not tied to the economy." I said, "He's right. He's right." But that's where now it's moved beyond hedge funds apparently to like high net worth individuals. They're looking for a place to park their money, and they're coming to a courthouse near you. So this is fundamentally changing our civil justice system. Now, it's not going to go away. So what I think we're going to see, and the last more recent change that I've seen, and it is a very substantial change, is the playbook from the plaintiff's bar. So I've been doing tort reform, I just use that, I know the plaintiff's lawyers don't like it, civil justice reform, for 30 years. The first 25 years that I did this, my time was all focused on passing joint and several liability reform, caps on punitive damages. It was about going out and promoting a pro-business agenda. And the trial bar's response was always just block that agenda. They were a group that just played defense for 25 of my 30 years doing this. In the last 5 years, they finally figured out we have virtually unlimited money. If you take how much money comes through, let's say asbestos is a $3 billion a year litigation, and you put on to that how much they're going to get in opioids, and NFL concussion lawsuits, and Camp Lejeune lawsuits, and talc, and Roundup, you're looking at an industry that is in the tens of billions of dollars, maybe 15 billion, more. It might be listed on the New York Stock Exchange if it was a company with one purpose, to sue and expand markets to suing. And what we're seeing is the plaintiff's bar has finally figured out they have enormous influence in state legislatures. Why just play defense? Let's go on offense and expand rights to sue, expand causes of action, repeal tort reform that's on the books, and create new damages. And so we're starting to see that happen. States that back in that first calibration had adopted caps on damages, some of them are now going in and repealing those, or unscrewing the cap, as we call it, or raising the cap. New causes of action being adopted. And again, hats off to the plaintiff's bar. They're not doing anything improper. They're entrepreneurs, and they're putting their money to work to change the law to make it easier to sue. But this is a change in tactic, and it's again going to have an influence on tort awards. We have more lawsuits, more higher damages. It's going to have an impact. So what I think is that these three really substantial changes that we've seen, third-party funding, the influence and the extreme wealth lately of the plaintiff's bar, and nuclear verdicts are creating an environment that is not sustainable. Companies cannot pay $10, $20, $30 million for routine cases. We are going to get to be a place where we are going to have insurance cost problems. I've seen it living in Florida. I've seen my premium in 3 years. My property loss, not for flood, just for wind. I've seen my premium go from $12,000 to $15,000 to $22,000 in 3 years, with a deductible that's now $75,000. I'm buying insurance that only protects me against my house burning down. Part of that is the hurricanes, but part of it's the lawsuits too. And people are going to realize that the deep pocket is their own pocket. It is going to affect new drug innovation. It is going to affect our homeowners policies and so forth. And there needs to be a balance. I respect the gentleman from Georgia who did a great job, and there needs to be people that are injured need to be able to have access to courts, and they have to be able to receive reasonable damages to try to make them whole. But $30 million, $50 million, $90 million, that's not sustainable, and that's not making somebody whole. That's just giving away money that ultimately we can't afford to do. There's just not enough money to pay that kind of money to everybody that becomes a plaintiff. So where does this go? Now to leave you on a high note. We are going to spend the next decade, I think, trying to recalibrate to some of these changes that are occurring on. And it's going to be very difficult for business because unlike the first tort reform movement, there isn't, you have comparative fault, you go pass joint and several liability reform. You have punitive damages that are going up, you just pass a cap. Okay, we're in a different environment where the things that are driving awards now aren't something where I can just say, let's just go write a bill. Because some of them are bigger than that. It's what's happening in our society, attitudes of the public and so forth. So it's going to be a much more costly. I think we're going to see defense costs go up, defense spend go up. There's got to be a response on the defense side to what's happening on the plaintiff side. If they have more money to spend and they're getting bigger awards, ultimately business has to respond somehow. And we're all going to pay the price for that in the cost of goods and services. But it has to happen because what we have now is not sustainable. The other thing that I see is some kind of recalibration on the defense side is a change in the funding litigation industry itself. I think if we're not there already, when you talk about $15 billion being invested and say $30 billion by the end of the decade, we will soon be at a point where there's too much money chasing too few good cases. So if you are in a market, let me make you the CEO of Burford Capital today, or any of these large funders. You reach the point by the end of the decade where you've saturated your market. What do you do to keep your stock price going up? You have to find new markets, right? You have to expand your market. So if I were the CEO of a funder, I would move away from just funding litigation. I would find ways to create it. And we're already seeing that in the mass tort context, where a lot of the advertising you see that the lead generators are doing, that's being funded by third parties. If you look at the rise of third-party funding in the United States, and you look at the number of the dollars spent on advertising, which is now $1 billion a year, those numbers track each other. All the ads you see on TV, that's coming from funding. It is. I can't prove that, but I can show two graphs that show funding going up and advertising going up at the same pace. Coincidence? I don't think so. But so if you're a funder, you've got to expand your market. So what do I do if I'm a funder? I go hire lobbyists to continue what the trial bar is doing, which is to make it easier to sue, pass tort deform laws, unscrew caps that are out there, and find new ways to sue. For example, like medical monitoring, pay people that have been exposed to something, but they're not sick. So the first thing I would do is expand my markets there. And then nirvana for them would be to stop being third-party funders and own the law firms outright. That's the next step. That's how you expand your market, is you just take over the law firms. Non-lawyer ownership of law firms is where this is headed. So that is not a recalibration, but I guess the trends that we've seen the last 5 years, I guess, is to say they're going to continue and they're going to change. And we all have to figure out how to adjust to that. So that's my pitch for today. I'd be happy to answer any questions that anybody might have. But as judges out here, I think it's important for you to understand this environment that we're in. Of course, this is going to be a pro-defendant pitch, but I think it's important for courts to hold the line on traditional values, Because some of these nuclear verdicts, you see, if you go back and say, well, whatever happened to that case 2 years down the road, many of them do get reversed or reduced. So what happens for the plaintiff is they spend 2-3 years in very expensive appellate litigation, and the same thing for the companies, and 2 or 3 years later, the plaintiff ends up in the same place he would have been if the case had settled at a reasonable number earlier on. What happens is the plaintiff's lawyer doesn't get the big headline, but the injured person probably isn't any worse off. They just wasted 2 or 3 years and not getting their money. I think that if you can hold the line on traditional values, that would be something that can help resolve cases and put money in the hands of injured people and maybe allow more people to go to court. Any questions? No?
So, Mark, if you can stay there, I'll start with a couple questions, but you can start lining up at either mic, and I'm going to return this mic over here right after I ask the first couple of questions. And we do have 15 minutes for questions, so feel free to think for a moment. So, Mark, the first thing I want to do is make sure that everyone here remembers their basic economics lessons from many of you have taken the Econ Institute for lawyers, right? And one of the key lessons you learned there is that correlation is not causation. So when Mark tells you that in the 1970s, everything started going haywire, and also the Law and Economics Center was started in the 1970s, correlation does not equal causation. But more seriously, can you talk for just a moment about the role of state AG offices in this evolution, and in particular about the idea that the incentives involved in state AG's offices, how they align with the incentives for the expansion in some of the areas that you've discussed, and how traditional political checks may not actually work in this space in light of those incentives, that whether you're a red state or a blue state SG or AG, you might have the same incentives to use the courts for particular purposes.
Absolutely. Thanks for that question. It reminded me of a joke years ago by Jeff Foxworthy, the Southern comedian. And I can't do his Georgia accent, so I won't even try. But and it's relevant to what's going on in Florida this week. He said, I've been watching the news with all these hurricanes, and I've come to the conclusion that trailer parks cause hurricanes. Because every time I see a hurricane, there's always a trailer park on the news. Anyway, again, so correlation, not causation. So the state AGs, really why that was successful, and for a number of reasons, and it's continued, is that it's very attractive. In some ways, the way litigation funding is attractive to plaintiffs' lawyers. It's a way to offload your risk and still get the reward. I think state attorney general, we're looking at the state AG litigation very similarly. It's a way somebody comes to you and says, this is almost like a deal you can't turn down, right? Somebody comes and says, hey, this is tobacco, but it's been repeated. I got a deal for you. I know you want to run for governor someday. People call the National Association of Attorney Generals the National Association of Aspiring Governors, NAG. Okay, so it's, hey, I got a deal for you. I know you want to move on and be a governor someday. So let's pick an unpopular industry to go after, whether it's cigarettes or lead paint or opioids, climate change now. We're going to find an unpopular industry and we're going to sue them. And the plaintiffs' firms, now the litigation funders, I suspect, are going to take on that risk. So you, the state, don't bear any risk. If you don't win, we don't win. It's a win-win for you, General, because if you win, you make all this money for your state, and if you lose, you've still taken on an unpopular industry and it hasn't cost your state anything. That's why it's so attractive to do this model. But there was a recalibration to some extent. After the attorney tobacco litigation, there were a number of states that passed good government laws. They're called Transparency in Private Attorney General Contracting, or TPAC, that essentially said if the state is going to hire a law firm, they have to treat it the way they would treat a government contract to build a road or a school or whatever. You got to put it up for a bid. And if the firm gets the contract, it doesn't have to go to the cheapest firm, because that's not always the best for the taxpayer. But it has to be the best for the taxpayer firm, and there has to be some explanation of why that firm was chosen. And after tobacco, there were actually some plaintiffs' firms that were calling for this type of thing because they got frozen out of that litigation simply because they hadn't contributed as much money as some other firm to the state AG's campaign. And so what you have now is this really attractive thing. And there was a response to it with these good government laws. It says there's got to be transparency in how those contracts are written. The contract terms need to be public so that the legislature can inspect them and make sure that the taxpayers are getting the best deal. Guess what happened in opioids? They bypassed the states and went to the municipalities. So that's I think, some may argue otherwise, but I think it was look, this is like a chess game or checkers. They go there, we go here. Opioids was a response to that. And so we'll see. But I think it's complicating now to drive that down to the local municipal cities and town level, how you put together a settlement. It's one thing to settle with 50 state AGs. That's difficult enough. Trying to settle with thousands of cities and towns, that's a monumental task, I think. So,
one of the
is
things,
that what you were trying to get at? Yeah.
It is. Let me follow up with one thing though on that. And so when I've talked, the Law and Economics Center, as mentioned, we run programs for state AGs, and so we talk to them about some of these issues. And one of the things that we've talked about is precedent establishment, and that state AGs sometimes have this, as you said, aspiring governors, short-term gains in mind without necessarily understanding the long-term consequences of the precedents that are established in a particular case. And you mentioned the public nuisance cases. I think that's one of those places where there may be an example where it may be very politically palatable and attractive to bring it for, say, opioids. But then all of a sudden, those same precedents of an expanded doctrine can be used in a different space that even, that may not fit the politics of a particular AG. Right. Yet they've kind of fed the crocodile, hoping it'll eat them last, to borrow sort of Reagan's phrase, right? And so, in part, do you see that as an additional issue with state AGs, the short-sightedness or the helping to establish precedent that opens doors later, and is that part of the overall playbook? And I guess for the purposes of the judicial audience, I think that that's also a risk when opinions are written in a way that might open the door, might solve a particular case, but be written in a way that it opens the door to a more novel theory in the future.
Right. It's it's a very perceptive point. I think the state AG may not be looking 2 cases ahead. The plaintiffs' bar or the funders certainly are. Where they're thinking, if we get this, where do we go next? Because I used to use the analogy that, with the state AGs, when tobacco was being considered, they all said, well, this is different. This is different than everything else. Tobacco is a unique product. And my senior partner, Victor Schwartz, said, well, with lawsuits, that's like putting potato chips in front of a plaintiff's lawyer. They're not going to eat just one. They're going to take the money and the new novel theory that's developed here, and it's going to go into the next case, and we've seen that. And I don't think the AGs are necessarily focused on the broader, longer-term impacts of these litigations. They're looking more often than not, I think, to get the immediate headline, to get the money for this case, and not really thinking, well, if we really change what is a public nuisance, what impact is that going to have on other people in the private sector and other litigations? I don't think they're thinking that far ahead.
So my final question then is, you had mentioned that some of the practical advice maybe for this audience is to hew to traditional values or principles or other things. But the one thing, and I'm not a judge, so I don't mean to speak for all of you, but you take the cases that as you get them, right? And so you can hear oftentimes, they can hear sort of this global assessment of the ecosystem, but they can't reinvent the ecosystem in every case, despite what you've helped them understand. So what tools are available to judges to play a role in the sort of sensible progression of the law in a way that fits with their judicial duty, but also fits within the understanding of the restrained opportunity to do so in light of the fact that they take the cases and the ecosystem as they get it?
All right, so this is like law school all over again. It's like my Blue Book exam. I'm writing furiously. So I would say, three things. When I started my career at Kroll and Mooring, Mr. Kroll used to say, three things, keep it to three. And so I quickly jotted down three things. One is, and I don't want to step on the next panel, third-party litigation funding. Judges can ask, what is happening in my courtroom? You are in control of your courtrooms. And you can require funding. You can require people to say whether they are being funded. A number of federal judges have done this. A federal judge in New Jersey, the District Court in New Jersey and the District Court of Delaware have case management orders in place. And I know in the class action context, the Northern District of California does as well. There are judges that have case management orders that say third-party litigation funding has to be disclosed. So that is something that you can do today. The other is expert evidence. So, and again, I don't want to step on a panel here, but you know that what happened after we talked about 1993, Daubert comes out that says judges have to be gatekeepers. In 2000, Rule 702 is amended to incorporate this concept, and yet many of our district courts and a couple of our circuits have just flat out not followed the law. If you look at the agenda books, I've got a law review article coming out later this year in the Texas A&M Law Review that goes through the history of the new federal rule, and it goes through, I call it the legislative history, where you read the words of the judges on the judiciary, the rulemaking committee. This is not me. This is the judges on the committee are looking at the cases, and they're saying things like, it's astounding to me that there are federal judges, many federal judges, that flat out are ignoring the law. These are the statements from the judges on the committee. They updated the rule last December, and it is not a substantive change. It is simply a clarification and an emphasis to tell those judges that we're not following the law. You need to do that. Whether you like the result or not, it is the law, and you have to follow it. That's what the new rule says, essentially. The judge, it says the court must decide by, it's more likely than not that the plaintiffs, or any expert, could be a defense expert, meets the reliability standards in the rule. It's out there. So opinions that say that there's a presumption in favor of admissibility, that was never the law. It never was the law. But you can go look in your 8th Circuit, 9th Circuit, district court opinions all over the country. You'll find opinions saying that admissibility is presumed. That is completely contradicted by the text of the rule itself. Nathan Schachman is here. He's an expert on this area. He can teach us all about it. But so they amended the rule to clarify the judge's gatekeeping duty for any expert, even for defense experts. It's a two-way street. Most states have rules that look like the federal rule. And so we're starting to see states amend their state rules to reflect the federal approach. Kentucky, Ohio, Michigan this year did it by Supreme Court order. Arizona, right after the federal rule was adopted last year, and in Louisiana by legislation. So that's something you can do. If you have expert evidence, one is read the rule. Don't look at case law, read the rule. That's the first place you ought to start. Read the rule and then do your job that the rule says you need to do. And that's the next part. And the next one is on remittitor. You may have one of these cases in your courtroom where you get the nuclear verdict. And again, I think it's important to look at what was going on there, and are the awards, excessive or fair, and do what's fair. But again, if you get awards that are clearly, the old phrase, shock the conscience, then I think you need to step in and show your leadership and do something about that. Those are the three things that I'd say.
Thank you. We have time for a couple audience questions, if you want to go to the microphone.
Hi. So I understand the law argument against or for third-party financing, but we're at Law and Economics Center. So from an economic standpoint, what's the harm in third-party financing? Won't the marketplace respond? Won't companies get sick of paying out these huge settlements? Won't stockholders get mad that they're losing money? Won't people start to hate plaintiffs' attorneys that are going after and kind of seen as these sharks? So I understand where we might be now, but won't that fix itself from an economic standpoint?
Great question. And if you have a panel with the funders, what they will all say is, we're in business to make money. We don't fund frivolous cases. We don't fund bad cases because we don't like to lose our money. That's not true. And this is why I think fundamentally third-party litigation funding is changing our civil justice environment. Because if you can now play with somebody else's money, litigate with somebody else's money, one, as the lawyer, it makes you much more willing to accept risk. Okay? The same way if you were to go to Vegas, I doubt many of you would put $1,000 down on a roulette wheel, right? We're in this job because we're not plaintiffs' lawyers, right? So we don't have money to go put $1,000 on. Now, if I gave you house money, right, what are you going to do? You're going to bet it because you're going to bet it all. And you may lose it, and you don't care, it's not your money. But if you win, you're going to get like super rich, right? That's what makes litigation funding attractive, because it's a way for the plaintiff's lawyer to unload that risk onto somebody else and share in the reward. Now, the funders themselves are able to unload that risk. Why are they willing to do what you as a rational person wouldn't do? Because they can fund a portfolio of cases. Just like you buy a mutual fund, you don't follow that mutual fund on a daily basis. You don't care if one stock loses all its value because you have 1,000 others in there that are going to do well and go up with the economy. So you don't have to pay attention to every individual stock, and you don't really care what happens to any individual stock in that portfolio because you buy enough, you're going to make money. That's why the funders can accept risk that lawyers can't. So they do fund speculative cases, and in many cases, junk cases, because they don't have to win every time. They only have to win sometimes. Now, Aviva and JJ, I don't know the numbers, but let me just play. This is always dangerous when I pull it on somebody in the audience. In the ovarian talc cases, I read somewhere that the company had won, I want to say 15 out of 16 cases, roughly. 16 out of 17 wins. The one loss, a $2 billion verdict in the city of St. Louis. Okay? So what does that tell you? Are these junk cases? If the plaintiffs lose 16 out of 17, yeah, they are. They're junk cases. But if you can get $2 billion on that 17th case, if you're a funder, what does it teach you to do? File them and file them and file them. Because if you can take 16 cases to trial and lose, but have generational wealth on the 17th case, or even the 25th case, you're going to keep going. So what it's going to do is incentivize people to fill up our courtrooms with junk cases, knowing they don't have to win all the time. They don't even have to win some of the time. Just one case out of many is enough to keep going. And that's how I think this industry, so don't buy this rhetoric that they don't fund bad cases. They're funding speculative cases that they know for the most part are going to be bad. But if they win 1 in 17 and the result is $2 billion, the incentive is there to keep going. And the same thing in the Roundup litigation. You look at the win rate for Bayer in the Roundup litigation. Not quite that good, but it's better than 50-50. The regulators believe that the product is safe. It's not banned anywhere. And the juries, for the most part, are believing that the product is safe. But there again, you don't have to win. If you're on the plaintiff side or the funder side, you don't have to win every case. You just have to win every once in a while. And so I hope that answers your question about how this industry is fundamentally changing which cases get brought in this country. And we're going to see a lot of cases that are really flimsy cases because the economics incentivize people to keep doing that.
Time for a short question and a short answer.
All right, I'm curious about your thoughts about a no-fault system or no-fault systems in order to take the lottery out of victim compensation. And I hesitate to ask because I think maybe defense attorneys have a stake in the adversarial aspect of this process, but it seems to me that that would, if you could guarantee compensation, fair compensation to persons who are actually victim because of the fact of their victimhood, without spending so many precious resources on determination of fault and cause.
You know, it's a great question, and you would think that is a solution. And I know early in my career, there was a professor at UVA that made his career, Jeff O'Connell, on no fault, particularly automobile no fault, and this would never happen today. There was a legislation introduced at the federal level early in my career by Senator Moynihan of New York, and I think probably Lieberman at the time. I don't think you'd get the two top Democrats to introduce a tort reform bill today. That's one of the changes that's happened too. But back in those days, we did, because they thought this is better for consumers. The problem then was that there didn't seem to be any champion for it to get that done. It was very complicated, and there wasn't a champion, but that may be something to look to. You know, my last thing about looking to the future, I'm always wondering, I'm not the guy to tell you about technology. I had a flip phone until 10 years ago, and my wife finally got embarrassed being seen with me with a flip phone. But AI, do we reach a point someday where we can have case resolution without the lawyers involved? Do we get to a point where we put in so much data, and people must have it, the data must be available today, when an insurance company is deciding, how much do I price the hurricane risk on my house? They've got modeling, that algorithms or whatever, that tell them what that risk is and what that cost would be. Maybe we get to a point, this is just my maybe as a thought to leave with, maybe we get to the point where there is a way someday in the future to harness massive amounts of data that could look at plaintiff's age and occupation and any pre-existing injuries and what happened, and plug it in and get a result. As you type in your data and it's almost like a claims handling process. You put it in and you get a check. You cut out the lawyers and you cut out all the costs. Maybe we get there someday, but I have a feeling that there's going to be powerful lobbying groups that would be opposed to that.